everyone. I'm Kim Coghill with ACA International in the Washington, D.C. office. ACA is the leading voice for the accounts receivable management industry. Before we get started on today's podcast about consumer tips for dealing with debt collectors, that registration remains open for the 2019 Spring Forum and Expo featuring Campus ACA Academy. This event is March 13th through 15th in Las Vegas. And regarding this podcast, the content provided is presented for educational and general reference purposes only. The content is not intended to serve as legal advice. Today's episode of ACA Cast with Jessica Hearn, the CFO and Compliance Director at Universal Fidelity in Katy, Texas. What should I do when I receive a call from a debt collector?
Collectors essentially are relaying the debt to the consumer to request payment. In some cases, collectors can work out payment plans or settlements to help the consumer pay the bill, and they must contact you through phone calls and letters. If you are contacted by telephone by a debt collector, I would say the first thing to do is to identify yourself when you are contacted. I know that is a scary thing to do this day and age due to the fraud and scams and identity theft, but collection agencies are regulated and they must identify the consumer that they're speaking to the proper person, so there is not third-party disclosure. The other thing I recommend is if you are worried about who is contacting you, you can always get their phone number from them and contact them back. Then you can verify that they're a legitimate business. You could even go even farther and check out their website or even look at the Secretary of State for the state that they're located in to verify their existence. Those are the first things that you usually have to do when contacted by a debt collector via telephone is to identify yourself.
Okay, thank you, Jessica. And as we're all aware, the accounts receivable management industry is highly regulated. Can you tell us some of the regulations that debt collectors follow?
The one leading regulation is the FDCPA that has been around since the 1970s. And this is protected consumers from harassment from collection agencies and has continued to be the law for consumers.
Can you give me the basic 101 on the FDCPA?
The FDCPA was designed to protect consumers from harassment and abuse, and some of those items that fall under that is the times that you are allowed to be contacted by collection agencies, which is 8 a.m. to 9 p.m. You may request to cease communication, but keep in mind this does not mean that the debt just goes away. They can not harass you. They cannot contact you at work if you've requested not to be contacted there. If you are represented by an attorney, they cannot contact you after the attorney information is received, but you need to be reminded that you should communicate your attorney's information to them. The collector cannot misrepresent the debt or use deception to collect the debt. They cannot publish the consumer's name and address on a bad debt list. They cannot threaten arrest or legal action that is either not permitted or not actually contemplated. No abusive language, no communication with third parties, and no contacting embarrassing media or report false information on a consumer's credit report.
So, Jessica, tell me, what can debt collectors do in terms of, are they allowed to call me whenever they want to? Can they call me at work? Can you give me some ideas about that?
Debt collectors can contact you via phone conversations or as well as letters. And phone calls and letters are regulated separately and what those need to disclose or information that needs to be used in the letters. When the debt collector calls you, they're regulated to call you between 8 a.m. and 9 p.m. If those times don't work for you, then you need to relay that information to the debt collection company so that they can find an appropriate time to call you. When they are calling you via telephone, they're going to identify themselves and the company that's calling you. They'll notify you if the call is being recorded, if they record conversations. They also must disclose the mini Miranda to you. The mini Miranda can be a little intimidating because for me, I think of the Miranda rights that officers read. In the mini Miranda, it will put in there that it is a contact from a debt collector, the purpose of the communication is to collect the debt, and that any information disclosed by the consumer will be used to collect the debt. They will also give you the name of the original creditor and the balance due. If the debt collection company or when the debt collection company contacts you through the letter, a 1692G notice will be sent to you, and that letter in itself has the regulated disclosures in that and some state disclosures depending on the state that you reside in.
Well, Jessica, speaking of Miranda rights, can a legitimate debt collector threaten me with criminal charges?
Absolutely not. That is not allowed. They can't misrepresent the debt that they're trying to collect on. They can't collect it with deceit. They can't use foul language. That part of the harassment is heavily regulated.
Jessica, what is the one takeaway from this podcast that I should know when a debt collector calls me?
I know at times many consumers get upset when they're contacted by collection companies, but I think a good thing to remember is you're speaking to another individual trying to perform a service for the client and their company to rectify a balance with the consumer. The collectors go through extensive training and testing to perform their job and duties, and they want to resolve the debt with you and find the best possible arrangements for you.
Okay, that's really great information, Jessica. We appreciate this. This podcast and ACA's other podcasts are available on ACA's website or wherever you normally download your podcast. Thank you and have a good day.